Welcome, everyone, to the third session of the Hands-on Law and Tech series. The idea behind this webinar was to create a platform, a space for the contributors of the research handbook on law and technology published by Edward Elga last year to follow up with what we've written, to discuss the new developments, and to put faces to those amazing chapters. And today's session is titled Revolutions, Evolutions, Revolutions in European Standardization. We'll be talking about standards. Now, standards is a tricky subject, both for legal dogmatics and for theory of law. It's, arguably a new development, which is becoming more and more important, and yet it creates a lot of theoretical and policy issues. But fortunately, today we are joined by three outmost experts in the subject who will help us understand it better. So I would like to welcome from the left, on how I see it on the screen, first Hans Micklitz, professor at the European University Institute in Fiesole, Florence, Giuseppe Colangelo, professor at the University of Basilicata, and Olia Kanevskaia, professor at the University of Utrecht. Thank you all very much for being here. We really appreciate you taking the time. So let's maybe jump straight to it. The first question, if I may, to you, Hans. I know you've done quite some research on how standards are being used recently in the new wave of digital legislation in the EU, but this builds on many, many years of your expertise with standardization. So if you could give us an overview of how they are being used, what the problems are, and what your thoughts on sort of where this is going are.
Thank you, Przemek. Thank you for the opportunity to present here some basic ideas. I will be, as agreed, extremely short and try to be provocative. So in order to understand the role of standards in the AI regulation, one has to go back to the mid-1980s, when the European Commission launched its project on the completion of the internal market. And in order to promote the building of the internal market, the EU launched a new regulatory approach, which is combined of two elements and a cooperation. So the element is that the law, EU law, is just laying down so-called binding legal requirements. And these binding legal requirements are then concretized through technical standards to be developed by the European standardization bodies, CEN, CENELEC, and ETSI. And the advantage and why business is so interested in cooperating is that compliance with these standards guarantees and allows access to the internal market. So this is a success story. The EU adopted since the 1980s more than 30 directives, very important ones on machinery, for instance, with a large scope, or in the construction business or whatever, based on this regulatory approach. With regard to, let's say, health and safety protection, what is equally important is that part of this exercise was to integrate product safety issues into the development of technical standards. So whenever products have a safety element, whether these are machines or consumer products, we have the same rationale: binding requirements and then technical standards. So that is the background. And now what happened and what the European Commission did, and what's now binding law, in particular with the DSA and with the AIA, but also in the field of cybersecurity and so on and so on. There are many regulatory recent attempts where we can find this type of co-regulation. The most prominent is the AI Act, And what the EU did is more or less to use this success story and to translate it from, let me put it like this, from the industrial world to the digital world. And the reasoning is more or less, we succeeded to handle product safety, and we succeeded to handle fundamental right, because product safety, protection against risks, is also a fundamental right. So we succeeded there, and we can transpose it to the digital world, to the development of AI standards, and to fundamental rights. So what we have in the AI legislation is now a mechanism, and there are particular articles, Article 40, which is saying, okay, so-called harmonized standards have to be developed by the European standardization organizations, and compliance with harmonized standard guarantees free access to the internal market, also in the field of the digital economy. So this is the logic, the rationale. There are many problems here.
Sorry, Hans, can I just interact? Because I think we stopped seeing you. Is it possible that your camera went up?
Oh, I'm sorry. I was better?
Better, perfect. Thank you. You were saying many problems.
I'm sorry. Yes, many problems. Let me start with the most important one. So there is a formula. It's a kind of a mantra of EU AI regulation. The mantra is human-centric, secure, and trustworthy AI. For a lawyer, it is worrying that this language has now to be concretized and in the very end to be given shape by the European Court of Justice. But politically, it is broken down and more or less concretized in the formula of fundamental rights. But what are the fundamental rights that can be used really as a benchmark? If we did it, we looked into the case law of the European Court of Justice and of the European Court of Human Rights in Strasbourg, and there are very few cases. That means this is a kind of a placeholder for an uncertain future. First element. Second element, something hidden, but quite outspoken in Article 8 and amazingly undiscussed in all these lengthy debates at the European Parliament and elsewhere, is that technical standards have to meet only the so-called level of generally acknowledged state of art. And if you go a bit deeper, you can find in this huge document, you can find an explanation. And there is one sentence, usually hidden, it's in Annex 2 under 1 and so on. Anyway, there is a sentence that I will quote. Begin, the state of the art does not necessarily imply the latest scientific research still in an experimental stage or with insufficient technological maturity. It means in the world of AI, which is extremely fast moving, that the lowest level, that what is generally acknowledged, is the benchmark. Okay, one problem, or second problem. Third problem. The European standardization bodies are the ones who have to do the work, or the standardization bodies at the nation states. In particular, important here are a limited number of national standardization bodies from France, UK, even if it is no longer in the EU, Germany, and the international standardization bodies. And now what is expected from the European standardization bodies and from the EU national standardization bodies is they have also to handle fundamental rights. That means that the software engineers, the mathematicians or the physicists developing these technical standards, they have to handle in one way or the other fundamental rights. And to tell you the truth, nowhere knows how to handle this. It's a kind of I don't know. It's kind of Ulrich Beck would have called it organized irresponsibility, because no one knows who is really responsible here. Is it the European Commission who has to check it, or is it the European standardization bodies who have to do it? I stop here. So that gives you a picture of the rather dramatic development that the EU has initiated with the AI Act in transposing a model from the 1985, from the industrial age to the digital age, and link it to fundamental rights. Thank you.
Amazing, Hans. Thank you so much for this introduction and overview. Indeed, the question of whether it is possible to manage risks to fundamental rights through standardization is an interesting one. We'll see how it goes, and the discussion is somewhat going on already. For those of you who are interested, we do touch upon this on the previous episode of the Hands-on Law and Tech. So if you want, it's also available on YouTube. But it is important to know, and as you mentioned, that it's not a new concept that is being designed for AI Act. On the contrary, right? Like we've been doing standards for a couple of decades now, and the question is how well will this fit? And so it's good to know the context. However, the context is also changing relatively quickly, especially with the new SEP regulation on the horizon. So as a second introductory part, could I ask you, Giuseppe, to give us an overview of that? That is, in brief, why is the regulation coming? What is it doing? What is it changing? And whether you think that is the optimal way to go.
Oh, thank you very much for having me. About the SEP proposal in terms of regulation, well, that's definitely something that the new European institutions are going to address quickly, because as we know, there has been a huge interest in coming from the European Commission to deliver this proposal. The proposal has been tabled at the very end of the term for a plenary session before the European Parliament, just to keep it alive for the new European institution. And I would say that there has been so much criticism about the proposal that involve apparently almost all the aspects of the proposal, starting from its justification in terms of market failure, also involving the entity that has been entrusted to take care of the implementation of the proposal, and also the three main, I would say, pillars of the proposal that are related to the essentiality checks, the friend determination, and reasonable, and the maximum reasonable aggregate royalties. Just to provide a brief review, one of the main questions is that why we need a regulation about the standard essential patents. And this is a pretty relevant question, because as we know, regulation is in general justified under a market failure explanation. So you have to demonstrate that there is something that does not work properly in the market and that require an intrusive intervention such as regulation. And in this regard, the goal of the proposal is to enhance transparency, predictability, and efficiency of SEP licensing. So the concern in terms of market investigation is that because of uncertainty, high transaction costs that in different way may affect the behavior of both implementers and patent holders, the SEP licensing system in Europe does not work properly. Nonetheless, this justification somehow is at odds with the findings of one of the main paper that actually feeded the impact assessment of the European Commission, so a paper that has been commissioned by the European Commission. And the findings of this paper is that actually there are no evidence of market failure that needs to be addressed. In particular, according to the paper, the empirical evidence reveals that there is no SEP litigation failure in Europe. According to the study, existing empirical evidence on the causal effects of recurrent ICP licensing conditions are largely inconclusive. It means that there is no evidence that friend licensing friction are causing patent holders to contribute less to standard development, or on the other side are inducing implementers to opt for alternative standard, that means without friend licensing. So apparently there is no indication that the current SEP licensing conditions are systematically suppress or delay the standard implementation. And that's, I would say, that's a huge problem, first of all. Then when it comes to the way in which this proposal intervene, actually this proposal is not just going to address specific issue related to the SEP licensing. It's going to introduce a complete overhaul of the licensing system. And in general terms, one of the main concerns that has been raised is that this proposal is not only apparently not justified, but is also unbalanced, is somehow one-sided. I mean, for those who are familiar with the standard essential patents history and dispute and litigation, it is pretty well known that the dispute around the SEPs is essentially a dispute about the underlying theory that justify intervention, both in terms of antitrust or in terms of civil law, and this time in terms also of regulation. That is the dispute between the old up and the old out theories supporters. Well, when it comes to the European proposal, it is pretty clear, at least to me, that the European policymaker decide to embrace just one part of the story. So rather than trying to strike a balance between old up concern and old out concern that are recognized all over the world and in the case law and in any kind of jurisdiction as two real problems that may affect the SEP license. So you need to take into account and address both the concern at the same time. Well, apparently the European policymaker decide just to embrace the old up theory of harm when it comes to SEP. Indeed, the entire cost of this regulation is borne by patent holder, and all the intervention is justified on the fact that implementers are somehow penalized by the system, and they do not get a fair share from their interaction of patent holders. So the traditional old up narrative. And from this perspective, there are, of course, huge concerns that tilting the balance in the relationship between patent holder and implementers, you run the risk to favor and promote strategic behavior on the other side that we know as reverse hold up or hold out. And just to provide a quick overview of which are the main interventions of this proposal. First of all, this proposal introduced several preconditions for accessing the competent card of the member state. It means that if you were a patent holder in the standard essential patents licensing system, you cannot enforce your patent if you do not previously register your patent within a system that will be created by the regulation, and you are unable to, and this pre-registration is functional to deliver an essentiality check over patent. Then you have also to go through a mandatory conciliation process that again is mandatory, so you cannot skip this process if you want to enforce the patent. And then there is finally also the possibility to agree on a maximum aggregate royalty. All these concerns all these provision essentially target one concern. First of all, the fact that there could be non-essential patents that are included in standards, in the standardization process. So the risk that patent holder may increase the amount of patent within the standardization process in order also to increase the cost for implementer and somehow customers. The risk that the litigation cannot be solved before the cards, because the cards, for instance, some cards may be more willing than others to grant injunction to patent holders. And so because of the injunction, patent holder may leverage this position to get higher royalties. From this perspective, there is a clear reference to the German approach to SEP litigation. If you read through the consultation and so on and so forth, it is clear that this concern has been brought essentially by the automotive industry, and in particular looking at the German case law that has been traditionally considered patent-friendly. And so let's put it also in this way. We have to take into account that the 98% of litigation in Europe are dealt in Germany. So when it comes to the Netherlands, France, and Italy, there are probably one or a couple of litigation in the last 2 decades. The huge amount of litigation are addressed by German courts. And so there is a concern that apparently, at least according to someone, the German approach is not fully in line with the so-called Huawei standard that has been delivered by the Court of Justice. And so one of the justifications for this regulation is that we do not want to allow the German court to have this so pro-patent approach. So there is also a mandatory conciliation process. And then there is the possibility to agree on a maximum amount of aggregate royalty. That is another provision that try to, let's say, to tackle a problem that is related to all that, but is called royalty stacking. That is the, let's say, the multiplication of the amount of royalty when there are so many patents involved. We do not have, at least in the first round, to get within the tail of this provision. What I would like to stress with you is that together with this amount of provision, what it is interesting that none of this provision is legally binding. So if you were a patent holder, you have to go through this process that will take time. And for instance, about the essentiality check, let's suppose that the entity in charge will decide that a patent is essential. That does not mean that the implementer may challenge this decision before a court. So you run the risk to spend a huge amount of time and money, because this is, again, just on the shoulder of patent holder. And at the very end, the final determination is not binding. The same is for the mandatory conciliation process. No one is legally binded to join this conciliation process, so the conciliator may be involved just by one party. The final determination of the conciliator is not binding, and to be honest, it's not clear how much a court will be willing to accept the determination of a conciliator, because of course this process is a process that shows somehow a distrust of the European Commission toward cards. And also the timing of this proposal, I would say, is not necessarily perfect, because this is the first time that we are seeing that the European Patent Court, the Unitary Patent Court, is going to deliver somehow decision around patents. So you may see that there could be conflict between cards and conciliator, because somehow you are telling that cards are unable to lower the litigation to address this problem, so I need to intervene before the litigation, before cards intervene through conciliator. And overall, there is a clear conflict between European Commission and German courts. That, again, is something that we are familiar with, because before Huawei, or let's put it this way, Huawei comes as a result of the conflict between European Commission and the German approach. So somehow you are bringing the clock back. And again, I don't know how much this will be healthy. And the very last point, from an industrial policy perspective, because standard is also a matter of geopolitics. One of the final questions that you may raise is, which are the benefits that EU may receive from this intervention? Because just to provide you a couple of figures, you may see that this is as I tried to show you, this is a proposal that is clearly pro-implementers, okay? So you may expect that Europe is an implementer country. It's not true, because less than 10% of implementers are based in Europe. So if you are complaining about the fair share of value between patent holder and implementer, and you are favoring implementer, actually I would say that this regulation is going to subsidize non-European implementers. Second of all, when it comes to patent holders, and the number that I'm sharing with you is not my number, a number that you may find in the European Impact Assessment, European Commission Impact Assessment. And about patent holder, you may see that according to the number of European Commission, in the last 7 years, the share of standard essential patents in Europe have decreased from 22% to 15%. So we have a drop of 7%, while in the same period, the share of patent standard essential patent owned by Chinese company has doubled. So right now, 1/3 of all standard essential patents are owned by Chinese company. So if I have to look from the perspective of geopolitical industrial policy, again, it's not clear which are the main benefit that this proposal may bring, let's say, to European economy. Again, there is a clear interest coming from specific stakeholders, in particular the automotive industry, and of course, all the economic interests are legit. I'm not questioning it, but overall, it's not clear the market failure justification. Is not clear how much are going to be effective the provision, and overall, is not clear which would be the benefit for Europe at all. Thank you.
Thank you so much, Giuseppe, for this wonderful overview. I have so many questions, but let's save them for later, because we have all the foundational ground to get covered. So it's not just regulations, statutory law that is changing, but also case law. And in this regard, Olia, if you would be so kind to tell us about the Malamud case and what was the problem there, and what's the legal framework as a result of it.
Yes, great. Thank you very much for having me here as a speaker for once. So I'm going to be talking about the case which is called Public Resource Organizations, referred to as Public Resource Organizations in Academia and Malamud in the Industry. Until very long ago, I didn't know that they're actually two parallel names for this case. Before I start talking about that, however, I have to kind of circle back to what Hans was telling about the success of the new approach and the success of harmonized standards. And while I completely agree with it, there is a catch. And the catch is that the bodies developing harmonized standards are private bodies. And they hold copyrights over the standards they create. It is their intellectual property. And this creates, in fact, two different but related problems. The first problem is that not only do we have what is in fact the law, and this is what the Court of Justice has been saying on a number of occasions now, standards are law. So we have law created by private parties, which is apparently also copyrighted. This is the first problem, because in a sense, how can law be copyrighted? But we also have a second problem of access, since standards bodies are completely capable and completely are in charge of who can access the standard, whether they are for free, how much money should people pay who want to see what's actually the content of standards, and so on and so on. So some standards bodies do put the standards just in private domain and offer them free of charge, for instance, Etsy. Others, like Sensenelec, sell them through their national member states, and there are also different pricing for those standards. So not only do we have now the law which is copyrighted, but we have the law which is copyrighted and behind the paywall. And this is, of course, a very peculiar situation. And given that we now increasingly rely on standards in the European Union, also in the new legislation like AI Act or DSA, but also for product safety, the case before the Court of Justice was bound to happen. And so it did. So in 2018, Public Resource Organization, which is founded by Karol Malamud, hence the reference to the case as Malamud, an NGO fighting for transparency, for access for public documents, supported by Right to Know, another NGO with the same mission, requested European Commission to provide access to 4 harmonized standards for the toy safety regulation. And the European Commission said, no, we don't do it because standards are held by private standard development bodies. They have the right to not to offer free access. And the request, by the way, was filed under Regulation 1049/2001, which is the regulation about the public access to the documents of the European Union. So after the Commission refused, the applicants went to the General Court of Justice, and they said, well, standards are part of the EU law, shouldn't they be available free of charge? The General Court sided with the Commission, saying that, well, actually, if we do make them available free of charge, we indeed harm the commercial interest of standards bodies. This was one of the many things that the court said in the decision, which was heavily criticized, and of course was appealed. So in summer last year, 2023, we had an opinion of Advocate General Medina, who was very critical about the General Court and even went as far as telling that standards should not be copyrighted because they are the part of the European law. And the European Commission, who mandates the standards, who also approves the standards, should actually play a bigger role when it comes to also offering access to the standards. And then on March 5, 2024, we finally had the decision of the court. And as expected, or as it was expected by many and hoped by many, the court overruled, the European Court of Justice overruled the General Court's decision, basically stating that, hey, if standards are law, they should be published in whole and access to them should be free of charge. So the public access to standards, in fact, prevails over the IP rights. Now, the decision was about the 4 particular standards for toy safety, but the expectations are that it will kind of also concern all harmonized standards, also standards for the AI Act that are going to be developed, so also the existing standards. All of them should be made freely accessible or should be published and made freely accessible to the general public. And this, of course, puts into question the financial model of standards bodies who rely on the selling of standards as their funds to conduct their activities. So the big kind of elephant in the room and the big question is, who will pay for making the standards free of charge and accessible free of charge? And I think I'll leave it here with this cliffhanger, and I will come back to this in round 2.
Great, thank you very much. Very interesting indeed. Though one does wonder, why did it ever start being priced at the front end in the first place, right? Like one could imagine a model in which all the standards were always publicly available and you have to pay for claiming compliance. But yeah, let's discuss it later. In the second round, the question I want to ask is, taking maybe sort of a higher and broader view of the developments we were talking about, what does it tell us, not only say about the actual geopolitical position the EU is in, but more like on the perspective we are taking vis-a-vis everyone else, right? Because the feeling I kept having both from your intervention, Hans, but also your Giuseppe's and your Olia's, is that it sort of seems like we are more and more accepting the position in which we are becoming that regulatory empire, right? Where someone else might come up with those new inventions, but we are this great market that, of course, everyone wants to be selling their stuff at, and so they just need to comply with our rules from the very beginning. But that seems to be more complicated, not least based on the numbers you were talking about, Giuseppe. So like what explains those choices? Hans, if you want to begin.
I'm personally very critical on this, on what is behind on the regulatory approach of the AI regulation. So the political level is we are guaranteeing that AI technical standards respect fundamental rights. And we in Europe, we save the world against China and whomever who are just using economic efficiency or misusing AI standards for whatever political and military purposes, including the US and so on, in variations. This, to my mind, is a very, very superficial perspective. Because what happens, and here I could give examples in the very same way Giuseppe did it. But if we look so far, where are the AI standards that are currently on the table, and who developed them? These are international standardization organizations. And the problem, the very practical, down-to-earth problem is the following. There are AI standards that have been developed since 2018 at the international level. And now the EU comes and says, hold on, stop. We have to check whether all these international standards are in line with EU fundamental rights. Yeah? So this creates all sorts of frictions. First of all, the very same people that have developed the AI standards internationally are now pushed back to the European table and to check whether they comply with fundamental rights. Yeah, which again, I repeat, it's a wonderful language, but again, I repeat the mantra, what does human-centric, secure, trustworthy mean in practice? Yeah, so my very fear is it's all about window dressing. We have a wonderful, gigantic regulatory monster, costly, yeah? And in the end, the business standards are developed internationally, and the EU will more or less accept them with a kind of decorative fundamental rights check. Yeah. So that means it's a little bit in the direction what Giuseppe, what you were saying. Yeah. A very costly mechanism is here established, and one may wonder what the benefits for the EU will be. Yeah. And I have my doubts that this approach will produce the results that in particular the Commission and the Parliament are expecting.
The costly part seems to be particularly worrying here, right? As in, like if you look at the paradigmatic example of the transatlantic divide, say personal data, with GDPR in the EU, the best regulation ever, and no regulation, no federal omnibus law in the US, totally unregulated. And the reality is that operating an online platform in the EU and in the US is actually relatively similar, right? Especially from the consumer experience. It's not that we have much less data collected about us, or we don't have direct personal marketing, et cetera, et cetera. And that's because in the US, there are all those industry norms, contractual relations that sort of require you, for example, to uphold cybersecurity standards, whereas in the EU, sometimes you do it, sometimes you don't. You just have a stock of paper saying why your purpose is legitimate. So you could say, okay, Europeans just like having all these regulations. It's mostly for the psychological reason, right? Like people want to feel safe. The Commission has
feel safe. Does not mean that they are safe. You know?
Yes, right. Like what people want to feel in the EU is that the union has taken care of them. It's rules are in place. Whereas what people want to feel in the US is that the government has not stepped too deep into the economy, right? Like let the markets roll. While the practice might be similar. The problem is it's such a costly monster to deal with, right? Like it's not free to write all those papers, all the documentation, but that's yet another question. Giuseppe, the same question, if I may. What do you think this approach tells us about how the union thinks about its role and where it's going?
Well, I couldn't agree more on what have been said before. But actually, I would say we are seeing this literally from the GDPR. I mean, the self-celebrated Brussels effect that actually belongs essentially to the Brussels bubble is something that is in line with the interest of European Commissioner, European policymaker. The problem is that that's just it. I mean, there is no assessing of the trade-off between cost and benefits. And when it comes to GDPR, again, it has been sold around the world as the best regulation. But actually, we know that several papers has highlighted the huge side effects of GDPR, and somehow how the GDPR has been unable to address, to tackle at least the competitive concern when it comes to the switching among platforms. Then, second of all, again, if you look at the way in which a policymaker legitimates itself, of course, is through regulation. But we are all aware of the fact that regulation is not the default rule; it's the exception. Well, in Europe, it's the other way around. We have regulated literally everything. Indeed, I'm concerned that the next European Commission will be probably a boring one, because I don't know what we have to regulate, and if there is something less on the table. And when you look at this perspective, also from the perspective on the side of the AI Act, you have heard around that there is this joke that when it comes to innovation, we produce 500 pages and other country invest $500 billion. But somehow it is true. I mean, the idea of promoting innovation through regulation is not just misleading, is without any basis. So we know that overall, in general, regulation usually is a barrier, is an obstacle to innovation. I'm not telling that the regulation should not have find any place in digital market or in this emerging technology. But it seems strange to me that we had in very few years so many regulations that somehow may also determine overlapping and conflicting solutions. Because I don't know if someone has decided to spend his life to creating a map in order to say how Digital Service Act, Digital Market Act, Data Act, Governance Act, AI Act, and other things that I left behind may work together. From this, and it seems that each of these initiatives has been delivered and drafted without taking into account that on a parallel track, there was another initiative. At the very end, this commission will definitely say, we delivered. We had so many flagship initiatives. Then there will be problem. This is because of the office, of bureaucrats, of the next commission, because we delivered. It is not the best way, let's say, to take care of European interest, it seems to me.
But Giuseppe, let us not forget, with the support of the member states in the end. Yeah, let's not blame the Commission and the European Parliament alone. Yeah, so the member states are
sure, because again, I see that there is a sort also political trend, political regain. Some of the member states or some of the authority involved suddenly regret to support, but you have to be able to, let's say, to defend your principle, even if when they are unpopular. The problem is that when you have a popular trend, apparently no one stand up and say, this is not the right path. And in a while, we will see so many people that are going to tell us that was not the right path. The problem is that the same people at that time have supported this trend, because again, answer is right. This is not just something that belongs to Vestager and Breton. I mean,
no, clearly it's sort of weird political situation in which member state governments both have an interest in having their residents happy that stuff is regulated and not taking the responsibility and actually having the Brussels to blame for everything, right? Like, say, in this country, we literally, the commissioner we chose was the commissioner for agriculture, and yet the previous government is who appointed them, blaming everything on the European Commission. You have to ask yourself, well, it was your guy who proposed it. You then signed it as members of the council, and yet we have this problem now. There are a couple of questions in the chat, but before we get to them, I just can't resist but asking Olia, so who will pay for the free law now that we have put this wonderful rule in place? Who will be financing the developments of?
There will be 5 years of litigation. Yeah.
I was just about to say the same. We will not know. No, to be honest, I mean, it's not. I think the question you asked, like, how did it come so far? That why is it that we have to pay for standards? I'm not sure how did it come so far in the EU. Probably Hans knows it better. But I heard that in the United States, where they have a comparable system, once they implemented the whole system of incorporating standards and laws by reference, the legislator or the regulators kind of assume that it will be gentleman's agreement that the standards will be just free of charge in public domain. That's how it will go. And this is completely not how it went. So who will pay? I mean, there are different options of who can pay. The most like the first option would be, of course, the Commission, but go ask the Commission to pay for the standards they put into public domain. I don't think that's going to happen. Standards bodies are not going to be paying, because for them that's the income. Some like were actually very happy. They were not happy, obviously, about the judgment, but they were happy that there was nothing ruled on the copyright, because the issue with this case is not what the court said, but what the court didn't say. And the court didn't say anything about copyrightability of standards. So I really foresee that in future we'll have also litigation about that. And then there are, of course, national standards bodies, which also sell the standards. So I wouldn't be surprised if Senelec will be kind of asking them to pay for the standards they put in public domain. But it also depends. I mean, we didn't have the reaction from the European Commission yet. The European Commission, which I think has been pretty exceptionally that they haven't really issued the reaction on the ruling. Typically within 2 weeks, 1 month, they have a position statement. Here they don't. So that also tells something, which is the Commission is watching, and the Commission probably doesn't know what to do. So there is also the question whether standards will be made publicly accessible at all, whether it will be interpreted like, okay, it was only for these 4 standards, or perhaps maybe those who want to see other standards, well, they can then file the request and we will see, and we will issue this on case-by-case basis, which completely wasn't in the spirit of the judgment, by the way. But I really see that the standards bodies kind of tweaking it in this way and trying to escape the obligation to put standards in public domain, to place standards in public domain. So who pays? There's a big question.
I think what I have heard, I don't know, Olia, whether you heard it too, but the rumor goes what the Commission considers is to allow open access, but only to read.
Yeah.
Yeah.
Yeah, like you on the version that they have sometimes in United States. So you can read, but you cannot print. You cannot
use it. You cannot use it.
Yeah.
So that means also for us, Olia, we can read, but we cannot publish our analysis. Yeah?
Yeah.
Because it's a derivative word.
Yeah? Yeah, I'm sorry, that's... yeah?
It's pretty funny. Great, thank you so much. We have two questions in the chat. The first one's addressed to Hans, but anyone who has thoughts. We also have the concept of state-of-the-art in the Product Liability Directive, also from the 1980s. I wonder what changes. Could it have changed without raising questions about the approach to liability, or was it just not right from the start? And the second question is, could you also discuss the risks of capture of the standard making process by the biggest market players? So if anyone has thoughts.
I think the two questions are interconnected, and they can be linked to the different levels of risks that are well established since, don't ask me, 50 years minimum. So you have three levels of how risk can be assessed. The first is the generally acknowledged state of the art. The second is the state of the art and science. And the third is the state of science. In pharmaceuticals, which was a big issue in the 1970s after the thalidomide disaster, introduced this second level. And in the film, in the nuclear energy, where all these power plants were established, there was huge discussion on what is the appropriate level of risk. And here we are close to the highest level, science. Yeah. So now, so that is the background. And now how they are interrelated. So we must distinguish, and Przemek, you did it already. In the US, we have a post-market control approach. Yeah, business can enter and can do what they want, but if something is going wrong, high fines, high product liability risks. In the EU, you have a pre-market regulatory approach, and that is what the AI Act is trying to do. Yeah, let's not forget, this is a pre-market regulatory approach. That means products should be brought onto the market complying with technical standards that meet the general acknowledged state of the art. So, fine. In the post-market control regime, the situation is very different, because here, whether these are public authorities or judges, they are confronted with a true problem, not a problem that is, let's say, artificial, because the regulator is thinking through potential risk, potential ones. But in the post-market control, there's an accident, or there is something, a risk that has materialized, and so on. And then judges, they take these standards, and that is the product liability, the answer to the product liability directive question. They take this as an assumption, but they are not legally bound. There was a huge discussion between the United Kingdoms and United Kingdom and the rest of Europe when the product liability directive was adopted, because what the what the UK wanted is to have a safe harbor. That means when companies comply with the standard, no liability. And that did not went through. So under the Product Liability Directive, which, by the way, is of very, very limited relevance so far. Yeah? The only country where it plays a role in practice is Austria, for very particular reasons in the Austrian system, legal system, civil law system. Forget the rest. All product liability cases are handled under general tort law in the rest of Europe and the rest of the world. With regard to the second question, capture. So I can only speak on the AI standards, where I investigated and spoke to all relevant actors, means to the big players, to the biggest market players. I spoke to the NGOs. I spoke to whomever I could get access to, and they all were ready to talk to me. And I have to say that I could not find here a clear capture regime. I think in the field of AI, what I learned from those who are drafting the technical standards and have been working on it at the international level, they were all struggling. Yeah. And they were all struggling. And the major reason is a difference between, let's say, the industrial world and the digital world. In the industrial world, you can, to some extent, predict potential risks. Yeah, you can, when you design an oven, yeah, to make it, give a simple example, you can imagine, okay, the risk that kids are touching it and that it's too hot and whatever. Yeah, so you can foresee it and you can set standards. In the digital world, you don't know how a particular AI system that has been developed by a provider, how it will be used by a deployer. This is near to impossible. This is something what all the people I interviewed from wherever they came from were saying. So I would not here see so much, at least not at that stage. Okay, that might change and so on. It's a field, as we know, it's developing very quickly. But from the interviews that I took last year, I could not identify that, let's say, whatever, the GAFAs are dominating standardization, yeah? And there is another element what we should not forget, and there is a link to what Giuseppe is discussing. In the field of AI so far, we have competition in standardization. Means all the big players are developing their own standards, and they have no interest in sharing them with the others, yeah? So then we are in the field of Giuseppe, where Giuseppe is more competent. I leave this to you.
Thank you. With a couple of minutes left, some final thoughts, Giuseppe and Olia, if you'd be so kind.
About ACPs, I can tell you that as well as in digital market, we are going to witness challenging times. And I would say that's good for us, at least for researcher. I mean,
that's true.
Yeah.
And for law firms.
Yeah. Yeah.
Those
and for consultancies.
Oh yeah.
Also echoing that it's going to be interesting times. At the same time, it is very remarkable how much has it been legislated and litigated in the field of standards. And I think it's, in a way, probably European Commission sort of waking up to a lot of private regulation or market processes that have been happening and wanting to play a role in there, not necessarily because they believe that the Commission is becoming irrelevant, but perhaps there are some issues of fundamental rights, human rights, and so on and so on, that the Commission realizes now, well, we let it go to new approach. Perhaps we should have been looking more at it. I'm not sure if litigating as much as European Union is doing, legislating, is a good idea, especially in the SAP world. I'm not sure what this regulation will bring us. Will the Europe be the innovation hub that the regulation foresees? I doubt, to be honest. But I think we will see that in a couple of years.
Interesting times ahead of us indeed. This was the last webinar before the summer and the last webinar before the European elections, after which the no longer so secret Mario Draghi report on how we're staying behind and totally over-regulated is supposed to come out. So we'll see in the fall, probably in October, there will be the next installment and we might wake up in a already different Europe. But for now, thank you so much, Hans, Giuseppe, and Olia, for your time, for your thoughts. Thank you, everyone, for dialing in. Thank you for the great questions. And yeah, wish you all the best. And remember, you can always read more in the chapters by our contributors in the research handbook on law and technology. So thank you very much and have a great
good day.
afternoon.
Thank you.
Thank
Bye.
you, Chairman.
Thank you for moderating.
Thank you all.